All right. Good morning, everyone. Can I get an indication if you all can hear me and see my video?
Perfect.
Good morning, and clear, thank you.
Fantastic. Thank you. Thank you so much. So my name is Brews Soyapi. I'm with Northwest University. I will be chairing the session along with Vicki King. Vicki, may you kindly show yourself and introduce yourself? Vicki, you're muted.
Yeah, no, thanks. Good morning, everybody. Nice to see you this morning. And I'm Vicki King. I'm environmental consultant and I work in Durban, and I'm assisting Kaifas this morning. Thank you.
Thank you very much, Vicki. So what will happen is I will introduce the speakers. I'll give an indication of the rules, what we're expecting today, and then Vicki will be handling the question and answer session afterwards. So in terms of time, there's 20 minutes per speaker. I will be very strict with the timeline. So I will indicate when you've got 5 minutes left for the presentation. And then I'll also make an indication when there's 1 minute left. Unfortunately, I'll have to interject whilst you're still speaking. We have a slight change in the program. The second speakers will now be the last speakers, and Leila will now be the second speaker. I'm not sure if everyone is here on the chat box, on the participants list, but yes, I think I see them all. Right, so the session is being recorded. The normal rules do apply. Please switch off your mics and your videos. You could perhaps maybe open them when we open the session up for the question and answer session. Start posting your questions on the chat box. You might get an option at the end to be able to ask your question in person. So I think, as you would have known now and have seen in most conferences over the last couple of years, it is now almost customary to have a session that deals with comparative perspectives. Why? Because we realize that there's always some value that can be learned from that. And if you look at the lineup that we have today, we have quite a diverse set of presentations. We have a presentation on access to environmental justice. We have a presentation on maritime spatial planning, and we also have a presentation on accountability. Or I will introduce the speakers in turn. So I'm not going to introduce them all at once, but only when they're about to speak. Starting off the session on comparative perspective is Mr. Mohammed Zakir Hossain, who is a senior judicial magistrate, also a chief magistrate at the Feni district in Bangladesh. The title of the presentation is going to be Access to Environmental Justice as a Constitutional Right in Bangladesh and South Africa. Are you ready for us, Mr. Zakir?
Thank you. I am ready for present my presentation.
Thank you. Are you going to share some slides?
Yes, I have a PowerPoint presentation, and I want to share a screen on my Zoom.
Okay, if you could try and do that. Khadimari, if you can assist, please.
Hello.
Good morning. Can you perhaps try at the bottom of your screen? Is there a green button that says share screen? There you go. See, something is happening. And then, of course, you can just open your presentation in the presentation mode as well.
Yes. Can I start my presentation?
You could, but maybe you want to put it on on presentation mode. So right at the corner, the top bottom corner rather of your screen, there's a computer shape. If you could just move your mouse right to the bottom of your screen to the right hand side. Otherwise, if that's a problem, we can continue as is.
I share my screen. Everyone is now watch my screen share.
Yes, we can see your presentation. Screen. We can see your screen. It's good. Thank you.
Thank you. I am a senior judicial magistrate of Feni district, Bangladesh, judge of Bangladesh Judicial Service. My presentation topic is access to environmental justice as a constitutional right in Bangladesh and South Africa. Firstly, I thank to the organizer ELA and I thank also to this session Search and other participant and the audience of these sessions. And now, firstly, I focus on Bangladesh about the environmental justice as constitutional right. Our constitution was adopted in 1972. That time, there was no specific provision in our constitution about environment, directly environment. Later on in 2011, by virtue of Constitutional Amendment 15 Amendment, Article 18A was inserted in our constitution, and this article is the state shall endeavor to protect and improve the environment and to preserve, safeguard the natural resources, biodiversity, wetlands, forest, and wildlife for the present and future citizens. This article is the part 2 of this constitution. It's called basic fundamental principles of state policy, which is not judicially enforceable. That means in our constitution, directly environment is not constitutional right, but constitutional development by the judicial this norms is developed, and now by the intervention of our judiciary in many cases related to environmental justice, it is regarded as a constitutional right, right to environmental justice. The famous case is Dr. Mohideen Farooq versus Bangladesh. It was in 1996. The Judiciary of Bangladesh intervened to recognize the right to environment as constitutional rights through public interest environmental litigation. And in this case, in this case, it was settled that right to environmental justice is regarded as right to life and right to protection of law of the citizen. That means 31 and 32 of the Constitution of Bangladesh, which is fundamental rights also. The Judiciary Affairs Court of Bangladesh interpreted that the right to environmental justice is regarded as the right to life. And by virtue of this liberal interpretation, now environmental rights is protected, and environmental justice is also developing norms and in the Bangladesh. Now I want to focus another important aspect of our constitution, that is any person aggrieved in the Article 102 sub-article 1. The Judiciary Affairs Court of Bangladesh liberally interpreted and harmoniously interpreted this term, any person aggrieved. That means any person who has sufficient interest to file any environmental matters and any other matters in the Affairs Court can be dealt with by the Affairs Court, and the question of locus standi cannot be seriously analyzed in those cases. The relevant case is Bangladesh Sanghatpatra Porishod versus Bangladesh, and the famous environmental matters case is Dr. Mohideen Farooq versus Bangladesh, 49 Dhaka Law Reporters Affiliate Division Phase 1 in year 1997. Jonah Rajak, an environmentalist of Bangladesh, she explained the notions is with the expansion of the meaning of right to life to accommodate environmental protection. The court created an expectation on the general public that judiciary would take more prominent position in deciding environmental cases. This is 100% true. Still now, Affairs Court on the environmental justice keep the pivotal role upholding environmental matters in our country. There are some famous environmental cases in this slide. First, Dr. Mohiuddin Farooq case I have already discussed. Another important case is Metro Makers and Developers Limited and others versus Bangladesh Environmental Lawyers Association, is known as BELA and others. This case is known also Madhumati Model Town case. In this case, the appellate division exercised its extraordinary constitutional power to complete justice. This article is 104 to protect environment and biodiversity in our country. And another important case is BELA versus BGMEA, Association of Business Entrepreneurs of our country. The case, the FX court ordered to demolish the tower, an important tower of BGMEA situated in the wetland of Hatirjil in our capital Dhaka. Another important case is Human Rights and Peace for Bangladesh versus Bangladesh. This case is, in this case, the High Court Division declared river as living entity and legal person. And it was decided on January 30, 2019. Many NGO and organizations are very active to focus on environmental justice, and they filed many cases in our the higher judiciary, and the higher judiciary decided very positively in those cases to uphold and protect and improve the environmental matters. Another important side is statutory laws on environmental justice in Bangladesh. That is dealt by subordinate court, and I am the judge of that type of subordinate court. And the basic law is Bangladesh Environment Conservation Act 1995. This is the mother law to deal the environmental matters in through the subordinate court. This act was amended in 2006 and 10. And another important instrument is the Environment Conservation Rules 1997. And the other very important legal instrument is the Environment Court Act 2010. It was firstly enacted in 2000, and then this act was repealed and updated in 2010. And other statutory laws to deal environmental matters in our country. But fact is, the environmental court, which is dealt by subordinate court, is very inactive. And very inactive, and the filing of the cases is not satisfactory. There are only a few cases dealt by environmental cases, and only 3 environment court was established in early 2000. The 3 courts are 3 divisional district. There is no later on there was no court was established, and 1 affiliate court which is in the capital Dhaka. There is no environment directly separate environment court in our country. The basic barrier to file cases in the environmental court which seriously restricted the access to justice is the environment court cannot receive any complaint directly from the aggrieved people, aggrieved organization, and any other stakeholders until the Department of Environment, which is government agency, files that complaint. That means the aggrieved person or aggrieved people must file complaint initially to the Department of Environment, to the executive body or judicial body. Then Bangladesh, in this situation, executive body gets primacy over the environment court, and the environment court, the filing case is very poor for this reason. Another important provision is a special magistrate court. A special magistrate, any senior judicial magistrate can perform as a special magistrate court. and the special magistrate it's a huge power, but there was no logistic support and manpower separately for the run this special magistrate court practically. In practice, the special magistrate court is very inactive to dealing environmental matters. Basically, mobile court led by executive magistrate, which is also executive, and DOE, Department of Environment, deal primarily environmental offense, and they only fine they imposed as punishment. For this reason, environmental offense we cannot reduce in our country properly.
You have 5 minutes.
Now I focus the environmental justice of South Africa. South Africa, the Constitution of 1996 is a very excellent constitution in the globe. The Bill of Rights, the right to equality, human dignity, and life, constitutional environmental right are granted as an enforceable right in the Constitution of South Africa. Article 24, the cardinal guideline, cardinal provision for the right to environment, and Article 34, Section 34, 38, and Section 39, which interpreted of Bill of Rights, are mainly deal about constitutional mechanisms and constitutional provisions of right to environment and environmental justice in South Africa. And there are huge statutory laws in South Africa on environmental matters. The basic law is the National Environmental Management Act of 1998, and other instruments also there. I want to discuss the basic difference on access to environmental justice between South Bangladesh and South Africa. From my research, I get some points that in Bangladesh, constitutionally, the right to environment of justice is not directly as recognized as constitutional right, but state policy. The right to environment is a state policy. On the other hand, South Africa, it is granted. Higher judiciary in Bangladesh, higher judiciary is the key role maker to promote environmental justice. On the other hand, constitution itself and constitutional court and judiciary are the bulwark to protect and promote environment in South Africa. Executive bodies controls the access to justice in Bangladesh. On the other hand, executive helps to enhance the access to environmental justice in South Africa. In Bangladesh, subordinate judiciary is kept inactive through executive unwillingness in access to justice on environment. On the other hand, lower judiciary also can keep role under the statutory laws in South Africa. Department of Environment in Bangladesh is the hallmark of barrier to restrict the access to court in Bangladesh. On the other hand, connected government agencies are bound to assist in environmental matters in South Africa. Lack of access to justice makes the laws ineffective in existing in Bangladesh. There are many laws, statutory laws, which are very, very instrumental and true, effective tools dealing environment, but lack of access to justice in the court on environmental justice matters, the laws are silently ineffective. On the other hand, exercise of laws through the access to application makes viable and effective in South Africa. And last one is Bangladesh should follow of South Africa. Bangladesh can develop from the legal development, legal enhancement, and legal thought for the South Africa in our, especially in our subordinate courts, statutory laws, and other government agencies to promote and protect environment. And South Africa can be regarded as a best one example and garnet example in this respect in promoting and promotion of environment. Lastly,
Sir, you've got about 1 minute to finalize.
Thank you. My presentation is almost completed. my last observation is South Africa is very much advanced in protecting and promotion of environment, and we are not in this. Our judiciary is very active, especially our judiciary. FX is very active as a role and keeps roles as guardian to promote and protect environment. And Bangladesh is also a good example to know and practice judicial activism in our court framework to promote and protect environment. Thank you. Thank you all.
Thank you. Thank you so much. We appreciate the time and effort. It's really interesting what I got from this presentation, that a country and a legal system that kind of restricts standing by having people have to go through a department is also one of the countries that also recognizes the rights of rivers, for example. I'll post a question related to that in the chat box. But thank you again, Mr. Hossain, for the presentation. Moving on next, we have Leila Neimane, who's a postdoctoral researcher at the University of Latvia, Faculty of Law in Raina. She will be speaking on maritime spatial planning know-how of the Baltic Sea region and the African Atlantic region, mutual learning possibilities. Leila, are you available for us?
Yes, I'm available. I wanted to find out about the presentation sharing. Shall I share it, or is it recorded?
It's really up to you, Leila. You can share your screen. The option is there to do that. Okay. Pressing the green button at the bottom, or you can just present. It's your choice. We can see your screen.
Yeah, you can see my screen, yeah? Yes. Okay. Yeah. I was already presented. Yeah, maybe some people in the audience know me already, because I was doing my doctoral research in the framework of Erasmus Mundus program at the University of Pretoria Faculty of Law for 1.5 years. It was 2015-2017, and then I managed to finalize my doctoral degree, and now I'm doing my postdoctoral research. And today I then present the background of the research, like from historical and geographic point of view. The aim of this particular research, I will give you a concise insight into the regulatory framework, and finish with the conclusion part. And as previously mentioned, I'm doing my postdoctoral project, which is supported by specific support objective activity postdoctoral research aid of the Republic of Latvia. And there are some not correct here letters, but basically, it is funded by the European Regional Development Fund. So this part of the research I developed in the framework of this larger project. I will talk initially about MSP, which stands for Marine or Maritime Spatial Planning. In Europe, it's more used Maritime Spatial Planning and abbreviated as MSP. And it is a general process that designates, integrates sea government through balancing the demands of development and the need to protect environment. And here you can see the most commonly used MSP definition, which defines it as a public process of analyzing and allocating the spatial and temporal distribution of human activities in marine areas to achieve sustainable objectives of sustainability, of course, and usually specified through a political process. Historically, MSP first developed in 1970s, and the most commonly cited and pioneering example in this regard is zoning for the Great Barrier Reef Marine Park in Australia, dating back its origins to the 1960s, 1970s. It was legislated in 1975, and the first plan was adopted in 1981. However, that concept in contemporary understanding has started its widespread application since beginnings of 2000s, especially of high-income countries in Europe, North America, and of course Australia, which I mentioned previously. However, while the initial MSP efforts and international events promoting the sustainability of marine environment focused on marine conservation, in the last decade, gradually the emphasis increased concerning blue economy and its sustainability. And it has been like some authors like Boyer and others put it that oceans is areas of opportunity, growth and development, and at the same time they are threatened and vulnerable spaces in need of protection. Consequently, there are two competing ways how the oceans can be framed. But as a result, MSP nowadays is the most commonly accepted management framework for the promotion of long-term sustainability and blue growth globally. So it is advanced as an essential and valuable tool which helps to implement ecosystem-based approach, and also it is dominant discourse regarding like blue growth and sustainable use of marine resources. On this slide, we can see the framework of the blue economy and different interests which are posing major challenges for the marine environment. For example, transport and port development, aquaculture, exploration and use of marine energy, which is nowadays very popular, as well as new underwater technologies and other. And here in literature and practice, there are many discussions about effective MSP because since it spread from 2000, beginning of 2000, it's quite new concept. And at the moment, it has been recognized that effective MSP means process which is ecosystem-based, place-based, integrated, strategic and anticipatory, adaptive, and also most importantly, also participatory in, which means in involving stakeholders in the process. Against this background, the aim of this particular research is to explore opportunities and challenges of the exchange of MSP regulatory and practical experience between the Baltic Sea region and the African nations bordering the Atlantic. Here we can see that Baltic Sea region comprehends, in the framework of this research, 8 countries: Denmark, Estonia, Finland, Germany, Latvia, Lithuania, Poland, and Sweden. Of course, Russia also forms part of the sea basin, but the research is focusing on these countries since these are EU member states also involved in the EU strategy for the Baltic Sea region and the Convention of the Protection of the Marine Environment of the Baltic Sea and are parts of the Baltic Sea, Baltic Energy Market Interconnection Plan. And in this regard, one must look also at the EU institutional framework, which is in case of MSP framed by 3 main regulatory instruments, which is integrated maritime policy, Marine Strategy Framework Directive of 2008 and MSP Directive of 2014. But of course, there is also a huge amount of other relevant legislation at different levels, and that's why I refer to notable Polish MSP researcher Professor Zaucha. He's presented intuitive levels in MSP it's in European context, which starts with MSP directive, includes afterwards regional organization guidelines, then national MSP plans, and also subnational and local level, like for example, building permits and investments in ports accordingly. Since the MSP directive required that preparation of MSP plans is finalized by 31st March this year, I give an overview of the current MSP status in Baltic Sea region. The situation in some sources, it was reported that only from all EU member states, only 6 respected this deadline. At the moment, situation is not so bad because most of countries have adopted the plans. These are 5 from 8 Baltic Sea region countries, and 3 other, they are finalizing the process, whether the plan is submitted for public consultation or for approval to the government. One also can see that the planning levels are different in the member states. It means MSP approaches also differ depending on the planning level, whether it's national, regional, like Germany, of course, it's federal and also state level. Other thing is that most of the countries in Baltic Sea region have quite advanced marine spatial data infrastructure, and for this reason they are also able to provide digitalized plan in GIS version, GIS version, which is the best format also for users and is quite implementation oriented. Because MSP plan gives like a vision of the use for the sea, and it is good if the description is well and written in a detailed way. However, exactly the map gives the best idea, and also in terms of time consumption, it gives the best overview of the planned use of the territory. So there can be drawn some good lessons from Baltic Sea region, which is also actually one of the flagships regarding, for example, MSP coordination and collaboration work, which is done by regional organizations like HELCOM and WASAB. Of course, all the countries have a sound legal basis, both on regional and national level. MSP directive supported the formation of this legal basis. Another point is that there are many pilot projects in this area which were used as the basis for the preparation of MSP, and there is also developed different databases consisting of spatial data which were gathered during these projects. One must point out that there are 2 countries which prepared second generation plans, Germany and Lithuania. Germany plan came into force on 1st September this year, quite recently, and Lithuania is still working on its plan. Another thing is also that Baltic Sea region presents important outstanding examples of the use of the sea. Most of, I would say, several countries are one of the leading in Europe regarding renewable energy production, like Germany, Denmark, Sweden, and Finland. And also Baltic Sea was one of the first regions which achieved the aims of the Convention of Biologic Diversity, allocating 10% of its area for conservation purposes. Yeah. The European MSP platform in this regard offers vast information resources regarding MSP in Europe, and not only Baltic Sea, but also different other sea basins. And there is also gathered information on legislation of the member states, as well as information on the pilot projects. Looking at Africa, we can say that there are like several MSP drivers in Africa, like African Union, Abidjan Convention, Secretariat, United Nations Economic Commission of Africa, and also MSP Global Initiative. African Union Commission has put more accent on blue economy, but at the same time, of course, MSP is like a mixture of and tool to achieve diverse sustainability goals, including environmental and social. And as for this reason, it is very important, the work which is advanced by Abidjan Convention Secretariat, which promotes 3 pilot projects regarding integrated ocean management in Benin, Cote d'Ivoire, and Ghana. And MSP Global Initiative offers also information on different like MSP development in different different regions of the world. So here is this Mamivata project of Abidjan Convention Secretariat, which I mentioned previously, and also the website of MSP Global, which is initiative of UNESCO and UNESCO Oceanographic Commission and European Commission together, and provides, as I told, information on different world regions and MSP development. I will shortly talk about Benguela current. Yes?
You have 5 minutes.
Yes, thank you. Benguela current marine large ecosystem countries, Angola, Namibia, South Africa, which are one of the first countries in Africa introducing MSP. It will be a short overview considering the time limit. There are several good points to mention what these countries have achieved. One must recognize historically they have had very good cooperation traditions regarding Benguela current large marine ecosystem, which also resulted in Benguela current convention, which came into force in 2015. And there was, under this convention, there was also created a special regional working group, which helped to pay attention, like not to put economic aspects into the front, but make combination of strong economic agendas with potential to contribute to conservation and social objectives. And at the moment, countries have visions regarding MSP and ocean use. Also, Angola and Namibia have prepared maritime spatial plan drafts. However, the difference is that South Africa has prepared also legislation regarding MSP, how it has to be regulated. But at the moment, Angola and Namibia is in the process of doing it and deciding what form it will take. And then I will finish with the conclusions, like in combination of all these initiatives which are happening in different parts of the world, one can see that in order to advance MSP, it's very important to use pilot projects also in South Africa, Namibia, and Angola. The pilot projects were used to develop MSP. And another aspect which is important is the establishment of sound legislation, because also in Europe before MSP directive, the situation was not so clear, and now it became much more coherent because MSP directive also guided the national legislation. There is always also challenge of management of emerging multi-dimensional maritime private and public rights restrictions and responsibilities, and it refers to the diversification of the sea, of the use, and that there are emerging new uses of the sea, like this new underwater exploration technologies. In order also to advance MSP, during the preparation of next generation plans, the digitalization process is very important, and that's why there is a need for maritime spatial data infrastructure, but also in Benguela current convention working group, the plan is also to prepare a regional database and to store spatial data there. And of course, for Africa, the most probably Angola, Namibia, and South Africa can also, in the future, serve as MSP knowledge and experience, give that they would provide this knowledge and experience also to the other countries. And the last thing I would like to mention that the process of MSP has proven that there are also new emerging legal principles which should be then legislated or applicated through high-level guidance, and the principles are listed here. Their content still needs to be clarified in the future, but they are dominant in the maritime spatial plans of the European Union at the moment. Now I would say thank you for the attention, and also invite to visit my project page on Facebook with using keywords MSP Baltic Sea. Thank you.
Thank you so much, Leila. You all had that, MSP Baltic Sea. It's really interesting because, am I visible? Thank you. So there is the LAMO project. I'm not sure how many people are aware of this, but there's the LAMO project that's happening in Eastern Africa, and it's actually been stalled because the marine spatial planning, what do they call these? They're like the environmental management plans. So the plans related to that did not consider participation, and they did not consider the cultural rights of the people that are living right close to the sea where it starts. So even though it's connecting Kenya, Uganda, and South Sudan, it's been stalled and it's been stopped in Kenya because of that. So I think the one big takeaway from this is the importance of integration, the importance of even regional integration, and specific legislation that is probably cross-cutting across these different countries. But thank you for that. Please ask further questions in the chat box. We will move on to the last presentation. I'm not sure if Hao is available now. Dr. Lefenya made me aware of the fact that he might not be. If he is not, we will only have a presentation from Dr. Lefenya. It might not be long, but Dr. Kesolofetse Lefenya is with the Northwest University Mafeking campus, and her presentation is dealing with enhancing accountability for environmental damage in South Africa, Zimbabwe, Mozambique, and Swaziland towards environmental justice. Doc, are you with us?
Yes, I'm with you. Thank you, Bruce, and good morning to all the colleagues, everybody who is on board this morning. I need to share my screen. How do I do it? Okay, here. Good. I will be presenting on my own. Unfortunately, my co-presenter is unable to attend this morning. He has a terrible flu, but nevertheless, I will continue. The title of my presentation is Enhancing Accountability for Environmental Damage in South Africa, Zimbabwe, and Swaziland towards environmental justice. This is an outline of the presentation. A brief background will be given. I will also give you a background on the recent riots that we have had in South Africa, Zimbabwe, and Swaziland or Eswatini. Later, I will define what accountability is and how the rule of law interacts with accountability. I will also give you a very short synopsis of the legal mandate on environmental rights in these 3 countries. I will also talk to how to enhance accountability with the objective of achieving environmental justice. There is a lesson to be learned, and we will talk to that. And lastly, the conclusion. Ladies and gentlemen, this is what we have been experiencing in the recent months in South Africa and other countries, the likes of Swaziland, Mozambique, and Zimbabwe. These are just pictures of what we experienced. And after all this, we can see the last page, the last picture at the bottom, that there's serious generation of waste. And one would wonder, now what then after all this? We've also seen serious oil spillages on our highways. We've seen marine life being impacted upon and beaches closing. Some activities had to be stopped as a result of serious damages due to the unrest that we experienced in the country and other SADC states. Let me start by saying that in recent times, some SADC countries, including South Africa, Mozambique, Zimbabwe, and Swaziland, have experienced widespread violent protests. This resulted in damage to infrastructure, loss of lives, decline in economic activity, environmental pollution, and exacerbated poverty, amongst others. These violent protests were fueled by various reasons, but the common consequence being the severe destruction of properties and environmental degradation and pollution. Now, all this has necessitated a need to explore how accountability for environmental degradation and pollution can be determined. I will give a brief background of the South African position. KZN and Gauteng have been rocked by riots and civil unrest at the beginning of July 2021, reportedly over the incarceration of former President Jacob Zuma. A number of shopping malls, buildings, and other infrastructure were torched, looted, and vandalized. As a result of these fires, as fumes from burning buildings and warehouses were being released into the atmosphere, hazardous chemicals were also released into rivers and wetlands. In Durban, in eThekwini, the municipality decided to close the beaches north of Umgeni estuary due to environmental and potential human health impacts of a chemical spillage into the Umhlanga Lagoon. The DA Shadow Minister of Environment, Forestry and Fisheries, Mr. Dave Bryant, said that the Umhlanga Lagoon appears to have been hit particularly hard after the release of those chemicals, with many dead fish washing up. This could potentially lead to further impacts on the lives of other animals and people who may consume these dead fish. Numerous species of marine and bird life were also killed by that spillage. The pollution has been considered very serious and could affect human health if species were collected and consumed. Again, in South Africa, many observers stated that the intensity of the fires meant that much of the smoke was lofted away from the immediate area. However, the monitoring site measured 2 hours of pollution that was around 10 times greater than average, which is very, very high. The air pollution was not just small particles typical of smoke, but it also contained many larger particles, presumably owing to dust from falling debris as fire-damaged buildings began to crumble. From these reports and observations, it was very apparent that there was serious, intense environmental damage and impacts from the violent protests in Gauteng and KwaZulu-Natal. Zimbabwe was not left spared. Between 2020 and 2021, there was a nationwide anti-corruption protests. Zimbabwe's human rights situation continued to decline in 2020 under the new president, Emmerson Mnangagwa. Security forces there committed arbitrary arrests, violent assaults, abductions, torture, and other abuses against opposition politicians, dissidents, and activists. In the midst of that violence and protest in the city center of Harare, there were numerous incidents of serious damage to property, fire outbursts, or torching of buildings. All these resulted in massive atmospheric pollution, generation of waste materials, and water pollution. The same was experienced in Eswatini in 2021. The ongoing pro-democracy protests started in May following the death of a law student, Thabani Nkomonye, allegedly at the hands of the police. Protesters were demanding democratic reforms and accused the king of repression. Some buildings connected to King Mswati were torched by protesters, and police were equally assaulting and arresting political opponents. Chaos was all over Eswatini. In Mazini, the country's largest city, protesters barricaded roads and government buildings, and properties of companies associated with the king were burned to ashes. All these actions also resulted in severe environmental damage, ranging from atmospheric pollution to waste generation and pollution at large. Now, let's get to accountability. Accountability, what is accountability? Accountability is the mechanism for ensuring conformity with the set norms and standards of action. In any setting where rules are established to guide human activity, supervision of conformity with those rules is an essential condition for the stability of that environment. Those exercising public power and discretionary authority must be answerable by being subjected to rigorous scrutiny, interrogation, and ultimately commendation or sanction for any degradation. In the absence of accountability, autocracy, despotism, and even dictatorship is likely to result. Therefore, accountability is a basic attribute of an open, democratic, and transparent society. When I talk about accountability, I would always refer to it or divide it into 3 categories: organizational responsibility. But I need to make this very clear. Accountability is not similar to responsibility. The two might seem similar, but they are not. But let me briefly talk to organizational responsibility. We have seen this. When we talk about organizational responsibility, basically we're saying organizations or structured can be held responsible or even accountable for actions of their subjects. We have seen that in KZN, criminal charges against an owner of a company that is linked to a huge chemical spill that killed tons of fish and destroyed other marine life or near the protected Mhlanga Lagoon, criminal charges being laid, we can start saying that a form of accountability is underway. Now, we also have state responsibility. it is often stressed that the rule of law, which I will talk to later, implies that not only the lawbreakers be held accountable, but also that the decision makers must as well give account of their actions. State responsibility for transgressions of international and domestic laws has long been a foundation of international law. A state may be responsible for even lack of due diligence if it has failed to prevent. Key here is the state has failed to prevent or punish violations of international human rights law committed by private actors, being you and me. We also have individual responsibility. Individual criminal responsibility is very fundamental to ensuring accountability for violations of international human rights law. International environmental law in particular here. We know that our South African environmental law is embedded, its foundation comes from international environmental law. In 1946, just a quick reference, the Nuremberg IMT, International Military Tribunal, pronounced that crimes against international law are committed by men, not by abstract entities, and only by punishing those individuals who commit such crimes can the provisions of international law and domestic law be enforced. Very, very important here. Now, what is the rule of law and why the rule of law? The rule of law is the bedrock upon which all nations are built. It is fundamental to peace and stability. All states have a duty to abide by domestic and international legal instruments. All states, and including individuals, are expected to be subjected to these laws, to apply them in their jurisdictions, and to be equal before them. The rule of law also strengthens mechanisms that enforce and protect universal human rights, including environmental rights. The Declaration of the High-Level Meeting on the Rule of Law has stated that all persons, institutions, and entities, public and private, including the state itself, are accountable to just, fair, and equitable laws, and are entitled without any discrimination to equal protection of the law. The declaration covers the breadth of the rule of law, including the importance of judicial systems to informal justice systems, transitional justice, transnational organized crimes and terrorism, corruption, and international trade. The declaration also reaffirms that the rule of law is indispensable for upholding peace and security, as well as sustainable development and respect for human rights. The rationale for referring to the declaration here is that the rule of law is the bedrock upon which accountability is determined. The challenge of determining accountability is an international challenge, and given the nature of our constitutions and their founding principles, the challenge may not have a solid legal solution. Now, let me quickly take you through the legal mandate, particularly on issues of the rule of law and the environment. In South Africa, we have Section 1C and 2 of the Constitution, which provides for the supremacy clause and the rule of law. We also have our Section 24 being the environmental right. In Zimbabwe, we have Section 3 of the Constitution of Zimbabwe of 2013. It says that Zimbabwe is founded on respect for the following principles: supremacy of the Constitution, rule of law, and fundamental human rights. We also have Section 73 of the Zimbabwean Constitution, which provides for an environmental right, which is similar to the South African provision.
Dr. Lefenya, you have 5 minutes.
Thank you. In Swaziland, we have Section 2 being the supremacy clause of the Swaziland Constitution, which provides that everyone has the right and duty at all times to uphold and defend the Constitution. Section 2161 of the Swaziland Constitution provides that everyone shall promote the protection of the environment for present and future generations, and that the government shall ensure a holistic and comprehensive approach to environmental preservation and shall put in place an appropriate environmentally regulatory framework. Now, what is environmental justice? There are different definitions to this. The South African Environmental Justice Networking Forum understands environmental justice as being about social transformation directed towards meeting basic human needs and enhancing the quality of human life, economic quality, healthcare, housing, environmental protection, and democracy. Bullard has defined environmental justice as a principle that all people and communities are entitled to equal protection of environmental and public health laws and legislations. Broadly, environmental justice refers to a combination of green and social justice issues, often referred to as brown issues. This discourse, for example, refers to such cases of hazardous industries erected next to impoverished settlements as opposed to wealthy communities. I'm going to skip this slide because it also talks to definitions of environmental justice. Now, what about environmental justice and accountability? Given the prevalence of violent protests in selected countries within SADC, it is very clear that the notion of environmental justice continues to be a dream that is far from being realized. In order for this dream to come into reality, there's a need for various accountability mechanisms to be put into place, and accountability being the order of the game. The question that remains to be answered is who must be held accountable, and how can those responsible for such environmental wrongs be held accountable for their actions as to achieve the principle of environmental justice? There's a lesson that can be learned from the South African position, in particular South African legislation. We have the NEMA with its very clear principles. The principle in particular here is the principle of duty of care and remediation of environmental damage. In Section 2, being the principles, responsibility for environmental health and safety, consequences of policies, programs, processes, and activities must exist throughout life cycle. Section 2 again talks to remedying of pollution, the polluter pays principle. In short, key is Section 28. Every person who has caused or may cause significant pollution must take reasonable measures to prevent such pollution continuing or recurring, even to rectify such pollution or degradation of the environment. The duty of care principle in Section 28 is also known as the environmental responsibility principle. It imposes on every entity, on every person, the duty to act with due care to avoid damage to others or even to the environment. A legal responsibility is placed on any person who causes harm to the environment. This duty extends not only to the originator, but also to the owners of land, of premises, persons who are in control of that land, persons who has a right to use the land or premises on which those activities or processes were performed or undertaken. Now the question is, can this duty be extended to organizers of those protests, owners of those businesses, and including the state? I guess so. The relevant authority may direct any individual in question to take certain steps to remedy the situation. I believe the relevant authority, the South African relevant authority, wherever they are in the process of this. Should recipients of such directives fail to comply, authorities can take necessary steps and then recover the costs, not just from the polluters, but from any of those persons that are listed above. These are the two, amongst others, relevant cases for purposes of understanding the duty of care. In conclusion, ladies and gentlemen, true accountability can be achieved only if national inquiry mechanisms are credible, independent, impartial, and transparent. And central to any effective investigation and prosecution is a successful witness protection. Unfortunately, politics plays a central role in those protests, and as such, witnesses might be intimidated to death. In order for environmental justice as a principle to be achieved in these states, it is of paramount importance that those who are responsible for the environmental degradation to be held accountable by using various mechanisms that are available in existing legislation. The duty of care and polluter pays principle should be at the center of holding people accountable for their actions. These are central tools which can come to the rescue of the current state of the environment in these specific SADC countries. Ladies and gentlemen, thank you for your attention.
Thank you so much, Dr. Lefenya. That was fantastic. I do not think we could have ended with a better presentation, especially one that deals with contemporary issues. And I can see in the chat box right now, the questions are burning. But thank you. I'm going to hand over to Vicki now, who's going to handle the question and answer session. She will be the boss going forth. Thank you.
Thanks, Bruce. Okay, that's been absolutely fascinating. Thank you, everybody. I've really enjoyed those presentations. And I think we'll start. We've got quite a lot of questions in the chat, so I think let's move to those. And the first ones are for Zakir, and I think let's take those two. There are two questions there. We'll take those first. Sorry, let me put my camera on. If the people who've asked the questions in the chat can please ask them directly. It's probably easier than me trying to read them from the chat. And put your cameras on whilst you ask the questions. So if we can have, I think it was Melanie and then Bruce, you had questions for Zakir. So if you can please, Melanie, if you can give your question. Thank you.
Sure. I'm sorry, there's a lot of background noise at home today, so please bear with me. Zakir has answered a little bit in direct message, but I'm sure there are other people who are interested to hear the answer. So I asked about how and to what extent the courts in Bangladesh have advanced environmental justice, and then as a follow-up, I asked a question about some of the leading cases. And yeah, I think, Zakir, I'm sure the broader audience would love to hear your responses.
I think my question was also kind of a follow-up to Melanie's, because I just wanted to find out the extent to which the judiciary in Bangladesh is becoming ecologically conscious, and if this ecological consciousness is streaming down to those who matter the most, like those in governance who have to make the decisions.
Thank you. Bangladesh, in my presentation, I stated that Bangladesh judiciary is very active to protect and promote environmental justice in our country. In the constitution, right to environmental justice is not constitutional right directly, but by the interpretation of the judiciary, right to environmental justice and PIL and PIEL both are recognized as the right to fight in the court. And since 1996, the first case on the environmental matters, which was Dr. Mohiuddin Farooq versus Bangladesh, this case was on a government project, and in this case, the judiciary liberally interpret about the Lucas standard, and any person aggrieved to the face And this explanation extended the access to justice in our country through FX judiciary. Day by day, the normative views of our FX judiciary is growing up. In the latest, there are some judgments which are delivered for protect the wetlands, rivers, and air pollution, climate change, etc. And there are some judgments which lay out some effective directions to the government to make some effective laws to accountable the polluters, polluter-free principles, and other sustainable developments based development. And the judiciary regularly regulate the government and governance to promote ecology, biodiversity, and other the forest and etc. In some cases, there are some guidelines and a declaration about the environment-based sites and environmentally important sites that are public trust property under the public trust doctrine. And through these notions, our country is now advancing, and our government is also convinced to make some viable change in terms of climate change, in terms of environmental protection, and other developmental works, which was before the activism of the judiciary. We never see such attitude. And another aspect is also our achievements also very wonderful. Though our statutory laws and subordinate judiciary is inactive in exercising in an enhancement of the access to environmental justice. This is very unfortunate, and we expect that our government will establish more environmental courts and move and remove the barriers of the executive barriers, filing the matters in our court directly. This is all, and we have our government now committed to make the country on the basis of the sustainable development. But that our judiciary is the policy. Our judiciary is the leading in environmental justice, because if judiciary was silent, the government never would speak such like to make and protect and improve the environment. In our latest legislations, there are some forms and some changes of the legislatures to protect and promote environment. And in the World Environmental Agencies, we are also committed to protect and to promote environment. Bangladesh is one of the countries who's established environmental code initially, but in this we cannot improve. The basic problem is in subordinate judiciary, the access is very limited because of government interference, and in the FX code, judicial activism is very vibrant and access to environmental justice is very wide, very wide. This is the basic development in our country. And now I would say, though directly right to environment is not constitutional right, but by virtue of the judicial activism, now right to environmental justice is regarded as constitutional right in our country. Thank you.
Lovely. Thank you, Zakir. That was great. I think that answered everybody's questions beautifully. I think then if we can move on to questions for Leila, there's quite a few there. First one we had was from Jahandri. So I think maybe Jahandri, Barry, and Kate. if you can pose your questions and then give Leila a chance to answer those. Thank you.
Hi, Leila. Thank you for your presentation. In your opinion, can MSP be used to regulate access agreements in fisheries of big foreign corporations, where the foreign countries are negotiating these agreements to the detriment of poorer countries, leaving these poorer countries with insufficient carrying capacity to allow for the traditional smaller operations of native fishing folk?
Thank you so much for your question. I would say that fisheries is one of the most complicated sectors for MSP, because even in one country itself, there can be clashes between commercial fisher companies and also artisanal fishermen, and those people who do it in artisanal ways, they are always more vulnerable and less protected. And such cases were reported, for example, in Poland. And between countries, I think MSP might enhance this situation, because one of its features, it's cross-border character. But then I would need to make a deeper investigation, because until now, in those MSP plans which I explored, they approach it this cross-border effect rather between countries which are close nearby, like in the Baltic Sea region. For example, some installations like wind parks, whether they would affect other countries. And as you mentioned, between foreign corporations and other countries which might be located more distant, at the moment I think there are applicable those sustainability fisheries partnership agreements which are concluded by the European Union and other countries where the vessels of the EU want to fish. But that is not directly related to the MSP. That's why I would like to thank you for your question, because it opens additional ground for further investigation.
Lovely. Thank you, Leila. Barry, would you like to pose your question?
Hi there, Leila and Vicki. Can you hear me?
Yes, I can.
My question really relates to the multitude of marine mining concessions that I know have already been allocated along the west coast of South Africa. And I was just wondering if the Benguela Current Convention has taken this into consideration at all. I'm not sure if you're able to answer that for me. Thanks.
Thank you for your question. I would say that convention, this regional working group on MSP, they set like the general idea for the region regarding MSP, like, for example, that stakeholders must be involved and the plans must be reviewed in 7 to 10 years. And at the national level, all three countries also have developed a comprehensive baseline report outlining also the current status of marine environment, and those data compromise ecological, economic, and social information, including also current uses of the territory. So these concessions are taken into account, and then considering, that is the approach also used here in the Baltic Sea, that the current status is taken into account as a basis, and what is done, that is done, and depending on what is already like existing use of the sea, the vision for the future then is created. I would put it this way.
Thank you, Leila. And then I think Kate's question sort of follows on from that. So Kate, you want to, I presume your question still remains.
Can everyone hear me there?
Yeah.
Okay, super. Thanks so much for an excellent presentation, Leila. And yeah, my question does kind of segue from what you've just mentioned. And in South Africa, we're seeing a proliferation of oil and gas applications along the coast. And I just wondered about your views on whether that preempts the kind of participatory process that the MSP process envisages if rights are already being allocated in these areas and uses therefore defined in a process where MSPs are still being developed. And I mean, I think South Africa has quite a long way to go before we do see some of those plans being implemented.
Mm-hmm. No, yeah, I thank you for the question. I would agree, yes, that in some cases territories are allocated and used already without public to be informed or to be involved in the process. But it is also related to the fact that MSP is quite a new phenomena, and uses which were like of the sea, they were before MSP was developed. So the MSP cannot really change the past, but just it provides this future vision. So yeah, we should hope for better future and more participatory also.
Thank you, Leila. Okay, Peter, you had a question, and Bruce, you just had a comment. So if we can have those, please.
Thank you, Vicki. Thanks very much, Leila. Great presentation. It was just about really following on also from Kate's comment, the use of the precautionary principle when actually deciding on conflicting proposed land uses. Has it come to the fore, and have you had any real conflicts? Thanks, Leila.
Yeah, actually, yeah, thank you for your questions. The application of the precautionary principle is a central part of the ecosystem-based approach, and the ecosystem-based approach is fundamental for the MSP. And yeah, and these uses in Europe, there have been different researches which can be found, also found on the European MSP platform, and they identify these conflicting uses. For example, it is like it can be fisheries and wind energy, or tourism and wind energy. There can be different clashes between uses, but at the same time, a new approach, which is largely applied in the MSP plans, is that they look for synergies and multi-use. Like instead of having the clash, they look at the opportunities which could be offered by combining both uses, of course, using technological advancements, like for example, on the one hand, wind energy production and fisheries can be like conflicting uses, but at the same time, there are ways how to organize these activities that actually they can exist in the same place.
Thank you. Lovely. Thanks, Leila. Bruce, did you want to make your comment?
No, it's a comment in relation to Dr. Lefenya, but it's really fine. Let's get to the questions.
Okay. All right. We've really just got a few remaining burning questions, which are from Melissa, and they're actually addressed to me, but I won't be answering them in this forum at this stage, except to perhaps say that you can't believe everything you'll read in the press. They relate to the UPL spill disaster, which was alluded to in Dr. Lefenya's presentation or talked about. I think, Melissa, do you maybe want to pose them to the forum or raise them at least? And if other people have opinions, we've only got just over 5 minutes left. So maybe perhaps just bring them up as pertinent and important issues to be raised.
Perfect. Thank you very much, Vicki. Yes, I know it is probably slightly controversial, but I really appreciated Dr. Lefenya's discussion on accountability and what that means. It's not just a matter of reading what's in the media. It's also a matter of looking at the law. And I suppose that's sort of where the questions come from. So I don't know, I appreciate that you might not want to address them at the moment, but I don't know if Dr. Lefenya had any specific comments about these. I mean, essentially to me, the central tenet of all of these questions is that there isn't really sufficient information, credible information in the public domain, and that really does affect our right and ability to access environmental justice in this context. So the first question was really just around why was then not an environmental impact assessment done, and what is the factual basis for that? I don't know if Dr. Lefenya has any insight on that. Obviously, the second question follows from that and really is, why is that basic facts not been made public? And then the last issue is sort of the notification requirements. And there, I mean, you would be aware that I'm not just basing this on reading from media reports, but it is sort of a central concern. So, ultimately the concerns are, it's all nice that we can speak in these forums about access to environmental justice and accountability and our different environmental laws, but it boils down to how we can practically enforce these things and how it works in practice. And this is now a prime example of how we ensure accessibility to environmental justice and accountability. Yeah, so I accept, Vicki, that you probably, don't want to necessarily address any of these questions, but I was wondering if Dr. Lefenya had any comments or insights on some of these aspects based on her presentation. Thank you.
Thank you. I'm just going to make a very brief comment on issues that you have raised and the comment that was sent via the chat box by Dr. Soyapi. You see, access to environmental justice and accountability has always been a problem, and it continues, and it will still continue being a very serious global problem. It's not only for the 3 countries that have experienced riots, because we've seen environmental degradation coming in all forms and shapes in different parts of the world. Yes, we may have legislation with all the nice and beautiful provisions, but it all comes from the executive arm of state. If there's no political will, unfortunately, to hold those responsible accountable, unfortunately, it will continue to be a dream. That's the reality that we must live with. As much as we can talk about environmental justice, but if the politicians do not come to the party, we, the environmental law practitioners, environmental lawyers, and activists, and APs, and everybody else, we can talk and talk and talk, but nothing will come to the fore. But again, when you look at tomorrow's program, Professor Kidd will be talking to some of these issues. I'm sure he will be in a better position to shed his insights into these complex, very complex, contentious issues. Thank you.
Thank you, Dr. Lefenya. I can only back that up. There's going to be papers written on this matter for years to come. I think there's an awful lot of material and interesting things coming to light. So thank you. Okay, can I hand back to you, Bruce? There's just one comment from Karen in the chat about that it's not the precautionary principle, but the precautionary approach principle, because if it was precautionary principle, we wouldn't build anything. So it's just an interesting comment. Okay, thank you. Can I hand back to you, Bruce?
Sure. I would like to thank everyone for joining us today. I think this was a very wonderful presentation. This is the value of comparative perspectives. I had one slight comment about my country, Zimbabwe. It's always bad that whenever we have conferences like this, there's always something bad to be said about a country. But other than that, this was fantastic. Coming next, I think at 12 is going to be the ELA Annual General Conference. And I think if you're an ELA member, you're invited to join. And then after that, there's going to be an open voluntary session that has to do with networking. The good old days are gone, so we'll have to do it online. I do not know if any of the executive members would want to say anything before we close the session.
I think just to thank you for running it so well, yourself and Vicki, but also to thank our sponsors, Judicial, for sponsoring the whole conference, and to thank our speakers today for their wonderful contributions.